Lauren Bartlett. Thanks for joining us. It looks like we've got about almost 20 people on the call, 17, 18 people on the call so far. Let's go ahead and get started. Others can join us. Please let us know if you have any technical difficulties. You can either interrupt me or enter a question into the chat box, and we'll try and get to you as soon as we can. Let me just make sure, can everybody hear me, and everybody able to speak at this point? Who's not muting themselves? If you have any issues with mute, you can use the audio pin which is given to you by GoToMeeting in the little dashboard box on the right side of your screen. And you should be able to join us. For those of you who are not who are not speaking, if you could mute yourselves, that would be great. So we're going to go ahead and get started. Again, my name is Lauren Bartlett. I am the project director of the local Human Rights Lawyering Project here at the American University Washington College of Law Center for Human Rights and Humanitarian Law. And this is going to be a presentation introducing you to the Human Rights in the U.S. Handbook for Legal Aid Attorneys. We're going to be using the handbook quite a bit, so if you can have a copy of it open on your screen, that will be best, or second best would be a printed version of the handbook beside your computer. But we're going to be going through the handbook and clicking on some of the hyperlinks, so best to have it open on your screen. So just to let you know a little bit about myself, I am here at the Center for Human Rights and Humanitarian Law. I had been previously a legal aid attorney down in New Orleans at Southeast Louisiana Legal Services for approximately 4 years before I came back to my alma mater to take this position working with legal aid attorneys to integrate human rights into your everyday work. And we're going to go ahead and get started. So again, this presentation is we're attempting to familiarize you all with the handbook. We're trying to provide an overview of how to use the handbook. We're also going to be covering the housing rights section as an example of a substantive legal issue section. So for those of you who may have been on the webinar in August, that webinar was just looking at the introductory sections and no issue areas. Today we have with us Eric Tars, who's the director of the Housing and Children's Rights areas at the National Law Center on Housing, National Law Center on Homelessness and Poverty. And he's going to be with us towards the end. He'll take over, so you don't just have to listen to me this whole time, and he's going to walk you through the housing rights section of the handbook. And also, we're going to go through a couple of sample housing intakes to sort of show you how to use the handbook in real time. Okay. So the Local Human Rights Lawyering Project, it's a 2-year-long project. We started last fall. We're continuing till fall of 2013. We selected 2 partners, Maryland Legal Aid and Texas Rio Grande Legal Aid. All of you on the phone and on the webinar coming from those 2 organizations. We've got 2 human rights coordinators who've joined us this summer. We have Rena Shah, who's the Human Rights Project Director at Maryland Legal Aid. We also have Nelson Mock, who is the Human Rights Coordinator at Texas Rio Grande Legal Aid. You all should know those 2 folks, or if not, you'll get to know them soon. And what are we doing? What is the local human rights lawyering project doing? We're providing technical, what is the center doing in terms of the project? We're providing technical assistance to both Maryland and Texas. We're providing legal resources, including this handbook itself. We're providing trainings like this webinar. We also had a March in-person training here in Washington, D.C., and most recently a labor and employment rights training in San Antonio, Texas at the beginning of August. More trainings to come. We also have 4 full-time consultants. Eric Tars is one of them. Sorry, not full-time on the project, just available at any time during the project on a limited basis. But Eric Tars is our housing rights consultant. We have Lindsay Gott, who is our domestic violence and immigration law consultant. We have Eric Pichal, who is our children rights consultant. And we also have Sarah Paoletti, who's our labor and employment rights, workers' rights consultant. And we also have an advisory board made up of 27 fantastic legal aid and human rights experts from across the country. All of the bios for the consultants and the little write-ups on the trainings and other resources that we're providing are all available on our website at www.wclcenterhr.org. You'll see that website again later. So in terms of the project, our overarching goals, and I just want to go through them with you really quickly, are to integrate human rights into the everyday work of staff at our 2 partner organizations, Maryland Legal Aid and Texas Rio Grande Legal Aid. So we're looking at integrating human rights into legal arguments before local judges and policymakers, and that's going to be the focus of this presentation webinar today. We're also looking at integrating human rights into the client-staff relationship, and some of you have recently heard us talk a little bit more about that in terms of the human rights principles for legal aid and some of the discussions we had in Texas. If not, you can talk to Rena or Nelson a little bit more about that. We're also looking to integrate human rights into office systems, including intake and staff supervisor relationships, and we'll be working on that more in the year or so to come. The Center for Human Rights and Humanitarian Law here at American University Washington College of Law supports human rights initiatives around the world. We work with students, academics, and practitioners like you all. We've got quite a few other projects, including an anti-torture initiative where we work with the UN Special Rapporteur on Torture to communicate about his current work and future work. We also have a Human Rights of Persons with Disabilities project. We have 5 human rights and disability rights attorneys who have come to the Washington College of Law for the next year to focus on getting their LLMs and working back in their own countries with persons with disabilities. We also have an initiative for human rights in business and some other projects as well. Just wanted to give you a taste of what we do. So we're a nonprofit attached to the law school who does work with students but also works with academics and practitioners and have a bigger picture view of our work. So in terms of this handbook, why does it say it's a draft? It says it's a draft in the file name. When you save it on the computer, it says it's a draft on pretty much every single page. Why does it say that? Well, there's 2 main reasons. The first is that the handbook is a work in progress, just a starting place. We want you all to add to it, to add arguments that work in your own jurisdiction with your own judges, add resources that you come across. When you have a success story, we want you to add that success story to the case studies in the case studies section. So we look at this as just we wanted to put together some information and provide you with a framework, but that this is your handbook, and we hope that you all can make it your own. by adding to it and editing it, and we are here to help you with all of that. But we really want it to be your handbook, not ours or for the general public. The other reason is we don't want you to share the handbook with anyone outside your office. That's why it says draft. And the reason is there are fairly strong anti-international law opposition groups at work in Maryland, in Texas, nationally. You may have heard 11 states in the last couple of years have passed anti-international law statutes attempting to bar judges from looking at Sharia law and international law in their decision making. So we don't want this handbook to be used to fuel their fire, and our advisory board, when they first saw this handbook, brought up this concern and has asked that, at least for the time being, and especially since it's in a work in progress, that it not be shared outside of your office. You also, as you will see, it has sample arguments that we wouldn't want to get in the hands of the opposition as well. So the draft label should remind you that the handbook should not be shared. Okay, so in terms of background on the handbook, how did we go about drafting it? We were really looking to get practical and usable human rights information into the hands of legal aid attorneys. So we were trying to use as simple language as possible. This is not an academic treatise. We wanted it to be accessible. We wanted legal aid attorneys to be able to explain to their clients why and how they were integrating human rights into their work. We also wanted this to be for everyday use, so that that's why you'll see the arguments are cut and pasteable. There's talking points that can be printed out. Citations are all here. We're looking at this as something you can go to and in less than 5 minutes find the resources that you need. We also are not worried about repetition. The folks that helped to draft this handbook we warned them that repetition was not a problem, that folks may not be reading every single section of the handbook, and so that if there was resources or citations that were repeated, that's not a problem in our mind. So going forward, let's look at the handbook as a whole, and I'm turning to the table of contents to do this. Part 1, which is the introduction, just introduces you to the Center for Human Rights and Humanitarian Law, Maryland Legal Aid, and Texas Rio Grande Legal Aid. It also provides principles for the drafting of the handbook, basically everything that I just went over. Parts 2 and 3 of the handbook are designed to introduce you to the human rights framework and provide the background necessary to strategically integrate human rights into your litigation and advocacy work. Part 4 of the handbook is designed to give you the specific information you need to make persuasive human rights arguments in state and federal court. And then Part 5 covers specific issue areas, so domestic violence, workers' rights, housing rights, consumer rights, rights to public assistance, children's rights, immigration, HIV/AIDS. We are also adding a disability rights section pretty soon. And we encourage you to cut and paste the sample arguments from parts 4 and 5 into your pleadings and briefs and print the corresponding talking points to bring to court. So if I can have, at this point, everybody turn to part 2, which is Human Rights 101 for legal aid attorneys. And I just want to show you that at any point in time you wanted to do this yourself, you can go to the table of contents, push Control, and then click on your mouse, Control, and then click, and it will take you to the section. So here we go. It took me to Section 2, Human Rights Law 101 for legal aid attorneys. And this works on any part of the handbook in the table of contents. I'm going to go back to my presentation. So part two of the handbook introduces you to the human rights framework and provides the background to strategically integrate human rights into litigation and advocacy work. So just to give you a little bit of background, international law is formed by written documents as well as common practices. One widely accepted definition of international law includes international conventions, either general or particular, international custom as evidence of general practice accepted as law, and judicial decisions and teachings of the most highly qualified publicists of the various nations as a subsidiary means for the determination of the rules of law. So each of these sources of international human rights law is introduced in Chapter 2. We have international conventions in Section 2.2, customary international law in Section 2.3, decisions of international and foreign courts in Section 2.4. And then, so let me go through some of these sections with you. We also have 2.5, general principles and guidelines, which I'm going to get to in just a moment. So part 2, Section 2.2.1. This is a sampling of conventions in the United Nations human rights system. So here we have the title of the convention, a description of the convention, the proper citation. The citations are in uniform format throughout the handbook. Now, the Blue Book only goes so far in terms of showing us how to properly cite international law and resources. You'll see that these citations are uniform throughout the handbook, but that different courts, different countries, different systems use different citations, and we've chosen one system, and you all are happy. I'm very happy to talk to you about choosing another citation form and explaining why, and how we chose the citation format that we did. But anyway, so this section gives you a sampling of conventions, provides you with the citation, provides you with the date. Now, the date refers to the date the instrument was open for signature. That's what this date column refers to. And then the U.S. action, ratified, not available, or signed only. Ratified NA is none, or signed only. So U.S. action would have been that the U.S. has ratified the convention, has done nothing, or it's only signed. These blue hyperlinks do bring you to the full text of the convention. We're working to add hyperlinks to reservations, understandings, and declarations where the U.S. has ratified a convention like the ICCPR. They will have done so with reservations, understandings, and declarations, and we're working. The next version that you see of the handbook will have a link next to the full text for the ratified conventions that will have the reservations, understandings, and declarations. And then we're also adding in little flags which will show you which conventions have been ratified. Both things came out of recent discussions with you all about how to make this easier to use, how to make this handbook easier to use. So again, just showing you here that you can click on this blue hyperlink and it will pull up the full text of the treaty online. I also want to point out that these citations in the sample of convention section, you can cut and paste even in the PDF document or in Word. Cut and paste them into your pleading or your letter or whatever it is that you are writing. And so you can cut, Control C and paste this into whatever document. And this will allow you not to have to retype everything. It will allow you easier, hopefully, easier way to put together your own brief, your own arguments. Okay. So Section 2.5, General Principles and Guidelines. So what are general principles and guidelines? They're secondary evidence of human rights law. These are similar to reinstatements, model code, or even Black's Law Dictionary. These are not binding, but instead they provide persuasive language, a distilled explanation, moral and political authority, and may even be evidence of customary international law. So this section describes them. A couple of examples of general principles and guidelines are the Boston Principles, which are in Section 5.7.8 of the Handbook, and the United Nations Guidelines for Consumer Protection, which are listed in Section 5.4.3. Okay, so moving on, let's all turn to Part 3 of the Handbook, Strategies for Effectively Using International Human Rights in Your Everyday Advocacy. Again, you can go to your table of contents and control and click on Section 3, and the handbook will take you right there. So Part 3, what is Part 3 all about? It's designed to provide you with a variety of different strategies of how to apply the human rights framework. So Section 3.1 covers how to perform human rights monitoring, documentation, and fact-finding, which can lead to documentation necessary to advocate on behalf of your clients with treaty monitoring bodies, covered in Section 3.2. The Human Rights Council is a specific example of an international human rights monitoring body which legal aid attorneys may advocate before through its Universal Periodic Review, covered in Section 3.3. Advocacy before special procedures, covered in Section 3.4, can also be very effective. Lastly, Section 3.5 covers how to bring a case before the Inter-American Commission on Human Rights, which is an international treaty monitoring body that hears individual cases brought against the U.S. for violations of human rights. Okay, we're going to skip ahead. Please turn to Part 4, Human Rights Litigation in the United States. So Part 4 is probably the most important chapter of the handbook in terms of where to dive in to human rights in state and federal courts. Part 4 is designed to give you the specific information you need to make persuasive human rights arguments in state and federal court. These human rights arguments are designed to supplement state and federal law-based arguments. So we encourage you to use the arguments here, the sample arguments, by cutting and pasting these arguments into your pleadings and briefs and printing corresponding talking points. So let's move through Part 4 of the handbook. Section 4.1, International Human Rights Law is difficult to enforce directly in U.S. courts. So again, these arguments, the human rights arguments, are not meant to be your only arguments. They're meant to supplement your state law arguments, which is seen in the sample arguments listed in the substantive legal issue sections. And you'll see when Eric goes into the housing rights section, you'll see how that's been done by some legal aid attorneys already. So human rights treaties are non-self-executing, and as I mentioned, when the U.S. ratifies a human rights treaty, we enter reservations, understandings, and declarations, which create problems for directly citing to these treaties as, anyways, we're going to have some more training exactly on reservations, understandings, and declarations. Just know that for now that it creates problems. There are also more of an explanation in the handbook. And we also want to mention customary international law does not require implementing legislation. So this is sort of a big issue, a big problem with applying human rights law in state and federal courts here in the U.S., and that we want to point out but not discourage you from trying to figure out ways to use it regardless of this big issue. And we're working on an entire chapter of the handbook on reservations, understandings, and declarations and the ins and outs, and hopefully by the end of the year we'll have that to be added to the handbook. In terms of section 4.2, this provides you with 5 sample arguments as to why human rights law might be relevant to a state or local court judge. I'm going to go through them with you really quickly. I'm running short on time, so I'm going to try and do my best to go through them as quickly as possible. So the first one is some state constitutions may support, if not compel, looking to international law for legal interpretation of domestic law. This is especially true in Maryland. The second one is that human rights jurisprudence may offer precedent and models that are far more on point for the case at hand than anything in the federal system or even sister states. And we can probably all together think of some examples of that. The third argument as to why international human rights law is relevant to state and federal courts is that state courts should interpret U.S. law as consistent with international law wherever possible. And I've provided a citation to the case Murray v. the schooner Charming Betsy. And this is the sample argument that 3, which is in the handbook. Each of these sample arguments as to why human rights law is relevant has a sample argument that we have put together for you, which you can cut and paste into your state court pleadings to explain why you might be citing human rights law in your state or federal court case. So I'm going to show you an example of this. This is from the right to housing section. So we have a sample argument, which is the right to housing and sanitation and water. This, we have the sample argument as to why international law is relevant to the court, and we add those together, and we get the full sample argument of what could be added to a state or federal court pleading. So this is a pretty long one. It definitely doesn't need to be this long, but it could be definitely easily cut down. But this would be an example of taking the court through first why the court should pay attention to international law, why it might be relevant, and then taking them through the right to housing argument and why the right to housing is applicable and relevant and applicable in this particular case. So that's sort of the idea of how we see the international human rights law best applied in a state or federal court pleading, is to build your case. And this is a sample table of contents from the state law brief, which you can sort of see how this builds. This particular case is the case brought by Pine Tree Legal Services in Maine, and what they did is you can take a look at the full facts, but you can see that this attorney made her state law arguments. She also looked at that's the number 1, running water is an essential feature of a habitable residence. She also looked at national standards regarding warranty of habitability, and then she went to international human rights law and looking at housing rights and the right to adequate housing and what that said about water and sanitation rights. So, really building a case and explaining not only using your state and federal law claims or relevant state and federal law, but also explaining then why international law might be relevant and how it's relevant, and inserting your right to housing argument. So we're getting almost close to having our guest speaker, Eric Tars, come on board, but I just have 2 more sample arguments for you, which are contained in section 4.2. So the first one is where there's no controlling U.S. law, state courts should look to customary international norms for guidance for their decisions. And this here I'm citing Roper v. Simmons, which is the juvenile death, case that the Supreme Court case that banned the juvenile death penalty. I'll have one last argument, which is more of an ethereal argument, but that state courts should be part of the transnational dialogue on human rights simply because it is a vital conversation that promotes universal values. So each of these sample arguments, as to why international human rights law might be relevant to a state or federal court. I think you have to really read your judge, know your court, and know when a judge might be swayed by one of these arguments and not the other. And I think that it's possible that certain judges will be more swayed by certain ones of these arguments, or maybe not at all. But I think it's important to know your judge and know your court. Part 4, Section 4.3, Special Considerations when the government is not a party to the suit. So I just wanted to point out this section. It's an important point, which is that international human rights conventions, by their nature, bind governments, not private parties. Right? They're contracts between governments, state parties. But so how is it that we would apply Human Rights Convention in a case where the government is not a party? For most of our legal aid cases, the government is not a party. So how do we do that? So there's a couple of examples I'm going to give you. The first would be a divorce case where one party might argue that a local statute discriminates against women or same-sex partners, right? So you would be arguing with the judge to interpret the law in line with international human rights standards or international human rights law. So there wouldn't be an argument. You wouldn't have to bring in the government, non-government part of it. You could be arguing for interpretation of the law in line with international standards, international norms. The second would be, say a party is arguing that there are third-party beneficiaries to a contract between the government and a private entity, such as a public housing contractor in an eviction case or a bank in a foreclosure case. You can see that the human rights arguments can apply to these sort of quasi-governmental entities, right? This is a more of a stretch than the first one where we're just looking at interpretation of a statute. But you can see that the human rights law could also be arguably applied in that second example. Okay, so we're getting on to Chapter 5, which is the specific legal issue areas part of this handbook. And we're going to go through the housing rights section today. The housing rights section is Section 5.3. So if everybody can turn to Section 5.3, the housing rights section, I'm going to turn this over to Eric Tars. Eric, thanks so much for joining us today. Yes, thank you so much.
Thank you. Can you hear me, everybody?
Yep.
Okay. Let's see here. And I have to show my screen. All right. Is my screen showing now, Lauren?
Yes.
Okay. Good. So thanks for having me today. I'm happy to be a part of this effort, which I think is, it's exactly where we need to be in moving the fight for human rights in this country into our domestic legal advocacy. I'm going to apologize in advance. I have a last-minute babysitting issue, so if there's any background noise, I will try and deal with it in as quick manner as possible. Where are my notes? Sorry. human rights, or the housing rights section of the handbook begins, as all of them do, with a brief introduction to the specific legal issue at question, providing some of the basic defining features from the international level, and talking about how it means to frame a case in terms of the rights at issue. These can be used as templates for your own work, and you can quote them directly, or you can alter them as you would see fit. My talking points and kind of introducing housing rights almost always include two other references in addition to what's here in the book. One is to a 2006 study done by the Opportunity Agenda that shows that 72% of Americans agree that housing is a basic human right. And the other is referencing Franklin Delano Roosevelt's Second Bill of Rights, and recognizing that the right to a decent home is something that is a very American value in addition to being a human rights issue, and so that kind of links these international human rights into our own domestic values. And I'm happy to work with people in developing your own talking points, for any cases or policy advocacy or educational materials you might be working on in terms of housing rights. The book also provides some domestic and international data and sources for data on the specific issue, in this case for housing, to add to your briefs, your memos, your community presentations, etc. And again, beyond what's just there in the book in front of you, I'm happy to work with people. Right now, for example, we have some great new data from the census concerning poverty and housing rights. We have new data from the Education Department saying that over 1 million children were identified as homeless by schools for the first time in the last school year. So there's some more current data out there, and again, I'm happy to share that with people. Each section then goes on to talk about the relevant human rights law that could be applicable in that issue area. And we divide that into sections for both ratified treaties and then treaties not yet ratified. The full discussion of the implications of ratification are earlier in the handbook. I find that since housing is an area where we have not ratified the most directly applicable treaty on the issue, the International Covenant on Economic, Social, and Cultural Rights, it's almost as easy, given the lack of recognition of human rights generally, it's almost as easy to talk about a treaty regardless of ratification in a legal brief, in any sort of policy argument. So you should always look for where the best language is, and then, if you can make the additional case that it's a ratified treaty, that's useful as well. Each section, each reference contains the hyperlink, again, to the specific treaty, so you can get the full language of the treaty. It has a full Blue Book citation for each article cited, so you can cut and paste that directly into your pleadings. And it's a kind of one-stop shop for all that you might need in integrating some of these treaty rights into an argument. The relevant law section then contains sampling of different domestic case law where human rights have been cited, starting with both U.S. state and federal court cases. And unfortunately, in the housing rights arena, we don't have a Roper equivalent, a case where, such as the Roper decision on the juvenile death penalty, a full Supreme Court decision, 1/4 of the decision was devoted to international and comparative case law. But we at the Law Center are actually working strategically towards that end. And we will, if people are interested in joining our working group on a right to housing, long-term right to housing litigation strategy, please feel free to contact me after the webinar, and we'd be happy to have you join that. The case law section then contains cases from international bodies, including the Inter-American Commission, Inter-American Court, International Court of Justice, various UN committees, such as the Committee Against Torture, etc. And I would point out here that there's a lot of different ways to come at looking for international case law. For example, on the issue of homelessness, there isn't a ton of case law out there, but this first case that deals with the forced evictions of Roma families. Roma families in Europe are, frequently housed in informal settlements, very similar to, the tent cities that homeless people in the U.S. live in, and so we often look at them as very analogous to U.S. case law or to the situation of homelessness in the U.S. and try and integrate those cases into our work. And then we have also cases for other national courts or sub-regional bodies, including the Supreme Courts of India, South Africa, sub-regional bodies such as the European Court of Human Rights. Again, the European Court of Human Rights has a lot of great case law on Roma for housing issues as well as education and discrimination generally. And both India and South Africa are fantastic sources of really progressive comparative case law. I would say, a lot of U.S. lawyers are doing themselves a disservice by not looking at some of this stuff because it's just fantastic language based on constitutional standards, often quite parallel to our own, that could be used in discussing and making progressive arguments here in the U.S. The section also contains treaty body and special procedures commentary and recommendations. These are different than individual cases, such as the one we just saw from Committee Against Torture, but they are on thematic issues or interpreting specific articles from a treaty. And one of the advantages of these comments is that you can look at either general comments, you can look at specific reports and recommendations on other countries and make analogies, but you can also find treaty body commentary and special rapporteur mission reports specifically addressing issues in the United States. We have a collection on our website exerting all of the housing references on the U.S. from the special rapporteurs and treaty bodies from about the past 5 years. It needs some updating, but I'm happy to share it with folks if they're interested, just to get a kind of broader flavor of what the potential might be. And it's also important to mention at this point that this is an area where you, as attorneys, can help to shape these references so that you can then turn around and use them in your future casework. We usually field 1 or 2 visits from special rapporteurs to the U.S. each year, and we're coming up on at least the treaty review process for the International Covenant on Civil and Political Rights next year, where people can submit shadow reports and try and get the treaty body to make specific commentary on the U.S. that we can then use strategically in our litigation and our policy advocacy. So if folks are interested in participating in that process, I'm sure Lauren can help you, I can help you, I can get connected on that. So now please turn yourself to section 353.4, either by looking at your table of contents and doing the control-click on the section, or just scrolling to that section. This section contains sample arguments specifically on housing rights, and each legal issue area section on housing, education, all the others contains about 3 or 4 sample arguments which we've developed to be cut and pasted into your pleadings. Or you can use, you can tailor them to your own judge and jurisdiction as you need to. The first sample argument we have here relates to the right to non-discrimination in housing. And beyond what's specifically outlined in this reference, I think it's often helpful to mention that under human rights law, discrimination, and that means racial, gender, disability, all of it. The definition of discrimination clearly encompasses both discriminatory intent and discriminatory impact. We have had some positive case law more recently, kind of re-embracing the impact part of the standard here, the Westchester case in New York, but this is an area where I think human rights can give a good boost to a judge just kind of looking to build on that case law and give them, yet another reason, one more kind of piece of support to say, yes, we should have a robust discriminatory impact standard as part of our jurisprudence as opposed to one that really, is discriminatory. You need to prove discriminatory intent just in another way. Sample argument 2 is based on the Salinger brief that was discussed earlier. And again, that case had to do with whether or not the warranty of habitability includes access to water and sanitation services. And deeper in the housing rights section, there's a kind of case study on Judy Plano, the attorney at Pine Tree Legal Assistance, who argued this case. We actually provided a lot of the language from the National Law Center that she then integrated into the brief. She had reached out to the Housing Justice Network listserv, and we kind of answered the call saying we don't have domestic case law on this point, but if you'd be interested in integrating human rights case law or human rights language, we'd be happy to give you support in that. And she took us up on it, and we integrated it into a great little brief. Unfortunately, it didn't get cited in the final decision, but at least the decision went clearly in the plaintiff's favor, and the justices didn't seem to be dissuaded in any way by including the argument. And this, again, was included directly into the plaintiff's brief as opposed to the in an amicus. The third sample argument is modeled after an argument that we made together with the Maryland Legal Aid Bureau in the Nickens case last year as part of their amicus that we submitted jointly for that. This was largely developed by some attorneys at the Legal Aid Bureau, and I'm sure they would be happy to talk more with folks about that. Each section also has some talking points that can be useful in oral arguments, and you can see that these are labeled talking points number 1, right to non-discrimination in housing. These talking points connect to the sample argument 1 on right to non-discrimination in housing. So where you have, and this is the same in all of the sections, where you have those sample arguments, you also have supportive talking points for using those talking points. So you're talking points 2 on sanitation and water, and 3 on self-help eviction. And these are things you can print out, integrate into your talking points for court, or going into a community presentation or whatever it might be. Each section also then contains case studies of legal aid attorneys again, such as the Nikolas case that I don't want to take more credit for than that was done by the Legal Aid Bureau. We consulted on it, but it was largely drafted by the attorneys there, and they did a really, 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 really fantastic job. And the links to these cases are in are hyperlinked within the text of the document. An update to this case is that, this was last updated as of March 2012, and I believe since then we have a decision from the highest court either accepting cert or actually deciding in the plaintiff's favor. I forget which, but I'm sure somebody from the Legal Aid Bureau can correct me on that. But it was, but it looks to be going in the right direction. We have the sample briefs in each section. Again, each of them hyperlinks, so you can go see the actual documents and use them as templates for your own. And if you have more resources to add, if there's other resources that are kind of listed, including, for example, our commentary. This is the link to all of those recommendations that I mentioned from the international bodies on housing. This is our manual on housing rights. So all those sorts of resources are there, and it's important to, again, reiterate that this is a draft of the guide, and it's intended to be updated by folks like you as you find additional useful resources that you think your colleagues would be interested in or able to use in their advocacy. So please contact Lauren, and she will be able to include those in future editions of the guide. So now let's walk through a sample intake and use the housing rights section to help us make our assessment and figure out how we can use human rights as a part of this. Lauren, on how you want to run this section, should we just give people a chance to read this and then jump in?
Yeah, thanks, Eric. I want to make sure everybody should be unmuted, so let me know if for some reason you're not able to join in speaking with us. There's an audio pin that you have to enter if you've called in by telephone to participate, but we've unmuted you. Can folks let me know if you can speak?
Can you hear me? Hello?
Yeah. Yeah. Great. Great. Okay. So I heard a couple of people. If I'm not hearing you, then let us know and we'll see what we can do, or try and use the audio pin. Oh, okay, great. So what we want to do is go through this intake, and why don't we give you a couple of minutes to read it, and then we'll get started. Lauren, it's disappeared from our screen. Oh, there it is. True. Okay, so what we wanted to do at this point was go through, you've got a client who comes in, this is the fact situation that you've been able to get out of your client. And now what do you do? How do you use this handbook? How is it useful in helping you figure out how you might integrate human rights into your case strategy? I think what we should do in the beginning is sort of open it up for thoughts from you all on how you might proceed, and we can point out some of the ways that we might use the handbook as you talk through your ideas for case strategy. Anybody want to start? Tell us some thoughts you might have on either using international mechanisms, or just if you want to talk through what you would do if this case came in your office without using international human rights.
This is Kelly Perkins at the Metro office. Practically speaking, if I got a case like this, the first thing I would do is review the notice, right? And then generally in the notice for public housing, they have a right to a meeting, which sometimes we attend, sometimes we don't, to try to convince them not to evict, especially if they have young children. And then they're also in public housing, at least in the counties I practice in, to do a supervisory conference, which is a more formal hearing, and then if that doesn't go well, then they can proceed to evict in the district court.
Okay. And so, in terms of trying to think through human rights advocacy, in that initial meeting that you have, I mean, what do you what do you usually do? Do you prepare with your client to talk through options? How do you go about advocating for your client in the first initial meeting?
Well, we definitely try to come to some kind of equitable agreement. This is the first instance. They've had no other warnings. Kind of explain what happened from the client's daughter's point of view. As to what actually happened, and then if that doesn't work, then obviously it's very informal, so you can tell almost right away whether they are going to consider it or not. But most of the time, they just say that they don't have any control over it, and then because it's a violent criminal activity, it's going to go forward regardless.
So, I mean. One idea here might be that you could, in that initial meeting, start to use some language, maybe not even say the words, human rights, but think about the fact that we're talking about a client and her family and her children losing their only place to live. We can also talk about the fact that there's probably issues going on in terms of children who have special needs, children who may be having issues in school. I mean, there's a lot of sort of right-based language that you can use, and maybe use actually saying the words human rights right from the start might put them off. But if you start to talk about, for example, I'm not going to change the screen so that you all can look at the intake, but Eric went through the sample right to non-discrimination and housing argument, which is the sample argument 3 in the housing rights section, and we can think through you could look through the Universal Declaration of Human Rights, the Article 25.1. Everyone has the right to a standard of right to a standard of living adequate for the health and well-being of himself and his family. We can also think through how the right to family comes into this, and sort of thinking about what happens in talking with the management about what happens if the client loses their housing and what happens to the family. Sort of trying to work. That would be the sort of the first idea, would be to try and work the language in, maybe not using the right to housing or using the treaty, citing to the treaties themselves. Does other people have other ideas?
Depending on the family or the people in the family's race, there could be a third argument, maybe.
The Convention on the Elimination of Racial Discrimination?
Yeah.
Can you explain? Is that Sarah?
Yeah.
Sarah, do you want to explain?
If these are, anyone in the family is not white, then third could be brought in based on, maybe they are retaliating against the family because they're a different race from the property manager or from other people living there. I don't have the convention in front of me, but that also goes to what you just said about right to non-discrimination and housing.
Right. Right.
On race.
This is Eric. In addition to that sort of the kind of short-term strategy, what can you do in that first meeting or in the follow-up meetings? You can also, take a step back and look at the broader situation, the context that this takes place in, and think about what long-term strategies might you need. I mean, obviously this all started because an unsupervised special needs boy hit a client's daughter with a glass beer bottle that was probably found somewhere in the complex. Are there kind of maintenance issues, sanitation issues, lack of place for people, for kids to play, those sorts of things. And there are really creative things that people have done. There's a group in Northern Ireland called the Participation in Practice of Rights Project, pprproject.org, that worked with public housing clients in Northern Ireland to document the conditions that they had a lot of maintenance issues, physical, the conditions of their apartments were deteriorating, the buildings were deteriorating. They had a huge problem with just accumulated pigeon dung in some of the common areas. And they documented all of these using a human rights frame, presented them, convened a human rights tribunal, of local notable figures as well as some international guests, and held a human rights tribunal, got a lot of media attention, and were successful in kind of changing the playing field for them vis-a-vis their public housing authority, and getting some of those maintenance issues addressed. So, that's obviously a much bigger kind of thing and much longer term. It may or may not help the individual client in this situation. But if you are seeing a systemic issue beyond just the individual issue, it could help, prevent future incidents and be a creative way to really educate the entire clientele, the community within the public housing units. You could also invite local judges, housing court judges or public housing commissioners to sit on the tribunal or attend the tribunal and educate them about human rights standards. So that's much a much longer term strategy that you could do, but it would, potentially have a much wider payoff.
Or something along those lines, but a little easier would be just telling the clients about their rights to organize and to a tenant council if they don't have one at this complex.
Exactly.
Are there other ideas? I also want to point out that part 3 of the handbook strategies for effectively using international human rights law. You could think through. Let's see. Sorry, it looks like. Let's see. I'm looking. It appears like there's a question from. We'll get it. Hold on, if you have a question, we're going to get to you. Sorry, it looks like there's a question that was unanswered. Sorry if we'll get it to you soon. But thinking through how you might use the Human Rights Council, the Human Rights Committee at the UN, the Inter-American Commission, if you want to go there, also special rapporteurs. All this is in part 3. If you see this as part of a bigger systemic issue, you could look through that section for specific ideas. Also, Eric, and as well as Nelson and Rena and I will be on the lookout for and let you know about specific opportunities where there's a special rapporteur who's asking for information or doing a visit, or there's opportunity for feedback. Upcoming will be the Human Rights Committee's review of the U.S. in 2014, and perhaps the third committee's review sometime beyond that. So thinking through other sort of international mechanisms and how to involve you all in that.
Can we move on to the next one?
Yeah, let's move on to the next one. Okay. Oops. Sorry about that, everybody. There. Sample 2. So I'll give you guys a couple of minutes.
There may or may not be a foreclosure expert in the room.
Okay. It looks like we had a long question too on the previous case. Maybe we can talk through that question before we get into sample intake 2. Sorry for the technical difficulties. But this question was from Sabrina, who said, one issue I often think about in the context of housing eviction is the client's removal from their community and local services. If client works nearby, has doctors in the area, child care providers, eviction will essentially destroy their sense of community and support system. Not sure if there are some human rights arguments to this effect. Do folks have thoughts on that one? Sorry to switch it up.
Sorry, I thought typing it would make it go through faster. I think it got stuck in cyberspace at some point. My apologies.
Yes.
Isn't one of the rights to housing have to do with being in a your own community?
I think it's accessibility to services and other things that are important to your life besides just having a roof over your head. I mean, I think impermanency and the fact that our clients go from one place to another is a really big issue, because you're either oftentimes our solutions are difficult solutions, because you can say, okay, if you have a child that's maybe a bad actor, then our solution is to take the child out. Well, that impinges on a right to a person to kind of keep their family together. Or our solutions are, well, maybe they can move out and relocate, and then maybe that impinges on their rights to have this community and have this accessibility. So I think, the way, I mean, it's just a difficult thing, because the solutions that we also have that we think would be a good outcome also kind of impinge on these human rights norms. So I think that's the difficult part when you're talking about housing issues.
General comment for the Committee on Economic, Social, Cultural Rights. That's what I was trying to remember.
That's great. I think I just wanted to point out in the introduction to the housing rights section, there's a little bit of a paragraph sort of defining the right to housing and the interconnectedness of the right to housing and other rights. But if he goes through the sort of aspects of the right to housing, and it includes availability of services, affordability, accessibility, cultural adequacy, which are all these, all sort of tied up in this question. Okay.
I would also point out, in addition to what's there, we put out a report last year going through all 7 of those elements from General Comment 4 and analyzing how they are being implemented here in the U.S. It's an imperfect assessment, but it's kind of an example of how we are taking those standards and trying to apply them at a federal level in terms of just analyzing domestic housing rights issues using that human rights language.
Okay, let's turn to sample intake number 2. Sorry to switch things up a little bit. So I know some of you on the phone deal with foreclosures, but even those who don't, what are some of the, maybe let's think through some of the issues that pop out for you with this one?
Hi, this is Vicki. I do deal with foreclosures. If it got to the point where the court was actually going to, there was going to be a foreclosure, and I was making an argument to the court in a situation like this that the court shouldn't allow the foreclosure to happen, well, I'd start out with the sort of the whole federal effort to stop and slow down foreclosures and an agreement with the banks, with the Attorney General's offices that that foreclosures should be prevented if possible. And then Maryland in particular has had some really drastic changes in its foreclosure law that our Court of Appeals recently recognized in a case saying that, now the impetus has changed from trying to expedite foreclosures and keep houses on the market moving to protecting families and protecting against foreclosure. And so all of that, and then kind of I guess to get a more human rights aspect into it too is the whole idea of security of tenure, and that this is a temporary setback for these people, and it's a it's a health and family issue, and it's the court shouldn't be helping entities like Bank of America threaten people's security of tenure in a situation like this where she thinks she's going to be back at work and be able to pay the mortgage again. And also, we would look at a bankruptcy for them too, to give them more time to pay back their arrears.
That's great. Other thoughts on this one?
As a legal aid attorney, I can't lobby, but I could tell them to lobby their legislators to require paid leave during pregnancy and parental leave, just like the Nordic states.
And again, this is Eric again. Kind of taking this step back, we could also, think about, my kind of classic example of what does the right to housing look like in practice is that, when we were doing the big bank bailouts, if there were, if the right to housing was part of the discussion, then in addition to, giving the banks $700 billion, we would have at a minimum put a condition on that they would have to, work with families to keep them in their homes. But instead we gave them all that money and put no conditions on it. And, the HAMP program is a week thing at best. We would have also, allowed homes, mortgages to be part of bankruptcy proceedings. Like all of those things kind of could get pulled into broader policy arguments that we would be talking about within the framework of the right to housing. So, again, that's the bigger picture. It's not the immediate case in front of you, but there could be, ways of using that case to connect to some of those bigger issues.
Another thought that I would have is that, in terms of interconnectedness of human rights, there's special protections for women and girl children. We're talking about a woman who at any point could give birth and potentially would be homeless if the foreclosure went through, though, it usually takes a long time. But so just thinking about trying to bring in some language about that as well, special protections.
Even though we haven't ratified CEDAW.
Yeah, but that's true in the Inter-American Court on Human Rights and the Inter-American Commission both stress that in many cases, including the Jessica Lanahan case, so you could use some language from the Commission in commentary as well. Well, are there any questions out there? We've got about 10 more minutes. I want to make sure that we have plenty of time for questions about the handbook, for Eric, about these sample intakes.
I guess I have a question. This is Sarah, who talks too much. The thought I have all the time in these kind of cases, like the samples, are basically if the bank or the landlord wins, then these people will be homeless, whether that means on the street or living with their sister in her basement or whatever. I mean, they're going to be homeless. And that's something I think I have actually said. I don't know if I said it in court or what, but I've argued that. But I don't have like a human rights link to that alternative if they lose, that they will be homeless. And I guess, what could I say, just something basic?
Well, I mean, in terms of, there's some good comparative kind of case out there. In Belgium, for example, they will not evict a family into homelessness, I think, at least during the winter. In South Africa, there's a duty not to evict into homelessness, and that's even in cases of squatting, where the occupants of whatever property don't even own the building that they are staying in or the land that they're staying on, and the state can't come in and just evict them without ensuring they have an alternative place to go. So there are some really strong examples like that out there. And if in your community, as is likely, the shelter system is either non-existent or overburdened, then you can make both an immediate argument for that family that it should be against the public policy of the community to evict a family or an individual even into homelessness, and that's definitely consistent. It's the kind of international standard, although it allows a state to progressively implement it. There are some core minimum standards, and one of those is that nobody should be homeless. So that, I forget exactly where that language is off the top of my head. If it's in the general comment or in some other commentary from the UN High Commissioner's Office, I think, as well. But that that language is out there.
We had another comment about the sample intake too. It's considered inhumane to leave someone homeless. In this case, a pregnant mother. Isn't there protection for that or some resources she could consider in this case? This is from Juan Chapa. I think, again, I think the Inter-American Commission, the Jessica Lanahan case, has strong language about protection for girl children and women that could be used. I would also say, if you look in, we could get some other, I can't think of any of the other treaties offhand, but can anybody think of any of the treaties talking about special protections for women and girl children?
Convention on the Rights of the Child and the Convention on the Elimination of All Forms of Discrimination Against Women.
Yeah.
These are straight up ratified because we are so advanced in this country.
Yeah, but still good language in those treaties as well. Were there other questions? We've got about 5 more minutes. I want to make sure. Any other questions about the handbook or comments or questions particularly for Eric about housing rights issues?
I'm also happy, my email is etars, E-T-A-R-S, at nlchp.org. Lauren can put you in touch. Your human rights coordinators can put you in touch with me if you have any follow-up questions.
Do you know when the disability section might be worked on?
It's being worked on as we speak. Hopefully it will be done in the next month or two.
Will they have mental health stuff in there too, not just physical?
Definitely, yeah, definitely. Yeah, well, that has been requested. And in the meantime, we can, think through specific cases. We also have a couple of advisory board members with lots of experience in disability rights and human rights law, so we can also put you in touch with them if you want to think through things in the next couple months before we have this disability rights section.
Do you know what the status of the convention is in the U.S. Congress?
So it's been sent to the Senate with the the Senate Foreign Relations Committee has sent it to the Senate suggesting that it be ratified, suggesting that they give their advice to the President, their advice and consent to the President to ratify. But as you know, the Senate has been on break, and so we'll see what happens in the next few weeks. It was sent at the beginning of August. Oh.
It's a little more nuanced than that. Even there's an amendment to so the President submitted it with a heavy package of reservations, understandings, and declarations that are even more kind of strategic in saying that it shouldn't have domestic impact. But in addition to those, an amendment was offered to the reservations package that would explicitly state that U.S. law, no U.S. law needs to be changed. We are already in full compliance. It's really obnoxious, and I think a lot of organizations are still supporting ratification, saying we should just get it ratified. It has good bipartisan support. Bob Dole and other former Republican leaders have signed on in support of it, so it's potentially one of the few fees we could actually get ratified. But to me, as a domestic advocate, trying to use these standards in my advocacy, that's almost too much to bear. So because it tries to remove any usefulness of the treaty in my advocacy. So we actually wrote a letter, joined a letter kind of saying we shouldn't ratify with these conditions, that we should remove that last amendment, and that upset a lot of the disability rights groups who were kind of like ratify at any cost. But I think if people are meeting with their senators on an individual basis, because of course none of you can do policy advocacy, definitely encourage them to ratify without that awful amendment.
Thank you.
Okay. We're going to go ahead. If there's no further questions, we're going to go ahead and end the webinar. I want to thank you all so much for participating. Thank Eric Tars for taking time out of his very busy day to join us. I also want to thank Christina, my intern, who's been helping with questions and technical difficulties. And thank you all for joining us. We'll be sending out an evaluation in the next few hours, and it would be great if you could fill it out and give us some feedback on the webinar. But thank you again, and Eric and I are happy to take questions by email if you think of additional questions. Thanks, everybody.
Bye.
Bye.
Bye.